We welcome you to the ANU ILS Career Series, Unravelling International Law. We acknowledge the Ngunnawal Ngambri peoples, traditional custodians of the lands on which this interview was recorded. We pay our respect to elders past, present and emerging, as well as any Aboriginal and Torres Strait Islander viewers. We hope you enjoy episode 5.
My name is Angelique Nellis and I'm the Careers Director of the ANU International Law Society. Today we have a remarkable and prominent international practitioner for the 5th episode of our video series. He joined us from his office in Paris, France. He has ascended to the pinnacles of the international law sphere, currently appointed as the head of the Paris Arbitration Practice at Simmons Simmons. Furthermore, he's been recognized as a world-leading arbitration specialist, regularly featured in the renowned Who's Who Legal Arbitration, as well as a leading international sports law specialist. In addition to all his specializations, he is a regular author and lecturer, most notably at the Hague Academy of International Law in January 2020, when I was very fortunate to meet him. Hence, on behalf of the ANU International Law Society, I would like to warmly welcome the outstanding Mr. Philippe Cavalieros. Mr. Cavalieros, it is lovely to see you again, and what a privilege it is that we can have you on our video series. Thank you so much for taking out the time.
You're most welcome. Thank you very much for this very, very kind and a little exaggerated introduction, but thank you anyway.
No, of course. Today, I not only want to focus on your notable arbitration experience, but I think it will be quite interesting to reflect on how you've kind of expanded on those skills in other international domains such as global sports and business. But before that, we can first delve into arbitration. So in episode 4, we were actually very fortunate to talk to Miss Claudia Salomon. She's currently the president of the International Chamber of Commerce International Court of Arbitration. So there our viewers really was introduced to the world of international arbitration, and we get a general sense of that area from the interview. So today I wanted to delve a bit further into certain aspects of arbitration that you are quite well versed in. So to begin us off, you have an array of notable achievements, such as being shortlisted for the Global Arbitration Review as the best prepared and most responsive arbitrator category, and have continued to really excel in this practice. So, but before all of this, you actually completed your master's in international law. So here comes my question. Having studied this, what caused you to gravitate towards arbitration?
Well, it was, I suppose, like many first times, it was a bit of luck. After my studies, I had studied international arbitration at university in undergraduate programs. And then I applied for a job at the ICC International Court of Arbitration, not knowing entirely what the ICC court did, I have to admit. And then I was hired, and it was my first job, and I should say my first foray in international arbitration. So I fell into the pot relatively early on, into the pot of arbitration relatively early on.
Yeah, and so with that, for the other law students watching here, how do you feel a degree in international law kind of equips you for the world of arbitration, or from your personal experience with that being your first job, how did you find the practical versus the experience that you had?
Sure. I think if you want to have a career in international arbitration, you have to study international law or international business law or international arbitration per se. So that's the natural path, I should say. Another one is mastering a few languages, which does help if you want to achieve a career in arbitration. But coming back to international law per se, I think, as I said, it is important, but one should not forget its own system of law as well, because I think at the end of the day, you need, in order to compare, you need to know at least two systems of law. So start by your own and then move up and do international law. That would be my advice.
I think the late James Crawford, who was the Australian judge at the ICJ, he was talking to Professor Hilary Charlesworth, and he said, in order to master international law, you first need to master, the black and white letters of domestic law. So
Exactly.
I think that couples very well with what he said. And I think from maybe talking more generally about arbitration, it will be quite interesting, as I said before, to kind of delve into how you use those skills in maybe other areas of international law. And I think this is quite fascinating, given, at law school, we study a lot of the books and a lot of the cases, but actually practical experiences may be a lot more different to what people actually realize. So first section would be international sports, and I know that you're quite well versed in this area, as I imagined. So as I've written here, I can imagine that you're quite an avid sports lover, and we both have briefly touched on that during the Euro Cup, obviously recently. However, your love of sport is not purely just personal, but it's definitely evident in your professional capabilities as well. So you're a judicial officer for the World Rugby, the European Professional Club Rugby, and normally part of an independent disciplinary committee in the sport as well. So having said all this, I was actually quite fascinated, and I was doing a bit of research, and I was reading an article about one of the decisions your committee has to make, and you had to assess the legality of a certain rugby tackle, I think it was, and you had to analyze certain aspects of video footage, you had to hear evidence as well as submissions. So in this case, and maybe others as well, how were you able to intertwine maybe more traditional concepts or use your skills of arbitration to different areas of the international domain, such as rugby and wider sports?
Thanks. That's a very good question. And let me start perhaps by the beginning. I think it helps that I've been a rugby player, or I was a rugby player, because I had to retire at some point. For many years, and played at semi-professional level in France, played one game at professional level. So it helps in understanding, for instance, the tackle you referred to earlier. That's one thing. Then coming more specifically to your question, what arbitration brings, or my experience as a lawyer brings to the process, is actually huge, because you realize that disciplinary hearings are short versions of a hearing, an arbitral hearing, for instance. It may last only a couple of hours, but you have the player in front of you, you sitting normally with two judges on the side. The lawyer usually chairs the disciplinary hearing. So you sit with two panel members, and the player comes usually with staff, a lawyer, sometimes a barrister, and the institution is represented by its own lawyers. So it's a very short, and it lasts maybe a couple to 3 hours, but it's a short version of an actual hearing. So in this respect, it is very similar, and obviously the right to be heard is fundamental. You want to give the player and his team every opportunity to explain what happened on the field.
Oh, great. And so that was a bit of the similarities. Is there, I'm sure there must be quite a few differences, but is there anything specifically that stood out to you that you found as a challenge or something different?
Well, I think you need to keep the right tone. In arbitration, it is, although probably a little more relaxed than in courts, it's still quite formal. In disciplinary hearings, it is also formal, but the player is usually not familiar with the process, and I would say a little scared. And that's the main difference. You want to put the player at ease. After all, we're only talking about sports with consequences. When you issue a ban, that has severe consequences, both personal for the player, but also financial for the club. So you try to put the player at ease. In arbitration, as a member of tribunal, you don't necessarily need to put the parties at ease. They are, after all, professionals, and they need to deal with their disputes.
Yeah, but it's great that you were able to couple your love for rugby and law in that sense. And I was actually researching a bit more about this niche area of practice, and it's stated in one of the articles that international sports arbitration has certain special characteristics, which you mentioned before, but it's also in many ways unlike commercial arbitration. But the article was stating how the margin appears to be closing in, because as the sports industry that we're all engaged in continues to grow, so does the significance of internationally recognized arbitral bodies. So here comes my question. Why do you think sports law or arbitration is an area to look out for? And what advice would you give to students graduating who may want to follow you in utilizing those skills?
Well, I think arbitration is truly an international field. So if you're interested in the world and not your domestic jurisdiction only, then arbitration is for you. It is a flexible yet very powerful way to resolve dispute, particularly disputes of international business. And I think it is the best dispute resolution mechanism when it comes to companies willing and wishing to avoid, for various reasons, state court jurisdictions. And I think it has been so successful over the years, over the last 40 to 50 years, that it has become the means to resolve international disputes.
And I think you mentioned the international business as well, and of course, given that the world is ever changing and becoming ever globalized, international business and international law is kind of intertwined in that sense. So I wanted to ask a bit, maybe delve more into international business in that category. So you sought to specialize in European business law, and you're a member of the ICC Institute of World Business Law. The intertwining, like I said, of the arbitrational skill and business skills, but most notably in your previous position as the head of the International Arbitration Department of the Renault Group, you oversaw Renault's acquisition of equity interest in Alovats, the Russian automobile company.
Afterwards, yes.
Yeah, for an amount, I think it was of 1.25 billion, as well as the overtaking of Renault and the Nissan alliance. So with all of that, when dealing with such high stake commercial matters, what is your process to kind of ensure an effective and enforceable outcome? What are the skills that you've utilized in these cases?
Well, I think you need to work. You need to work relatively hard. I think the positions you have as in-house counsel is somewhat different to external counsel, as I am now. It is different because as in-house counsel, you need to run the business, understand the financials behind it, understand the political force within a company in order to make sure that the case is moving on and progressing. And you need to drive also your external counsel, but you need, most of all, I think, you need to make sure that your management understands that you are there to facilitate the business and you are there as in-house counsel to help, basically. As external counsel, it is slightly different because you are asked to do usually one thing, either the contract or preparing documentation or doing the due diligence when it comes to M&A deals. And so you're more focused and you are more of a specialist on a couple of areas. As in-house counsel, you have a broader picture, yet unfortunately sometimes you don't delve into the micro details that make our job as external counsel so interesting sometimes.
Yeah. And so if that was an example of the in-house kind of matters that you had to deal with currently right now, how would you describe the work that is done by Simmons Simmons and maybe more your area of what you're working with?
Well, Simmons Simmons is an international law firm with a number of offices worldwide, about 23 offices. In Paris, we are almost 100 lawyers with 23 partners, and we cover virtually every aspect of the law. Our dispute resolution team, of which I am a member, comprises about almost 50 lawyers in Paris, which is quite significant, and we are in this respect a heavyweight in Paris. And within that, I am responsible for the, as you said in the introduction, for the arbitration team. And so I cover every aspect of arbitration matters, from drafting the arbitration clause to monitoring and defending clients in arbitration, but also acting as an arbitrator.
Wow. Very, very busy schedule, I can imagine. And I think going on to our final question, I was reading one of your articles, I think it was called Guerrilla Tactics in International Arbitration and Litigation. And you stated that, similarly as you stated previously, that over the last 20 years, arbitration has become the norm of settling disputes. And I think you mentioned just then that it was the dispute resolution in the field of international commercial business. So with this, I wanted to kind of get your opinion as to what you see as the trajectory of international arbitration in, let's say, the next 20 years, and how you believe law students should kind of engage in this futuristic arena.
But I think international commercial arbitration has a bright future. Mm-hmm. So if students are interested in arbitration, they should focus on international commercial arbitration, as opposed perhaps, particularly from a European Union viewpoint, to investment arbitration, which has been affected by the European Court of Justice. But beyond that, investor-state arbitration has also a future in Africa, possibly in Asia, and continues to be important in Latin America. But coming back to commercial arbitration, and as piece of advice perhaps to students is, and you're the perfect example of that, Angelique, is not be scared of studying abroad, show an interest in other jurisdictions, in other forms of law, in other practices, work on your language skills, and just go out there and do everything you can to succeed. Apply in law firms, continue to apply in law firms, apply again in law firms, if you want to be a lawyer, of course, and get out there and get as much experiences as possible. Do internships, read books, write articles, even if it's merely on a blog, just write something, show an interest, and then you will be spotted by potential recruiters.
Yeah, I think you're right. There's a lot of opportunities, and a lot of times it's actually seeking those out and kind of putting your best foot forward and putting your name out there and trying to seize those opportunities, which is sometimes the most important thing. But I think that's a nice way of concluding our brief interview here. I'd like to thank you so much on behalf of the ANU ILS. We truly appreciate you taking out the time during your morning to engage in our inaugural video series, Unravelling International Law. It's wonderful to see you again, and I definitely believe that a lot of students listening to this will find it very useful. So thank you very much for joining us.
My pleasure. Thank you very much.
Perfect.